Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammy. I am Executive Director and Vice President of Legal Studies at Washington Legal Foundation. We're very pleased to have you join us on this final day of September and final day of the third quarter of 2025. It's hard to believe we've gotten this close towards the end of the year, but certainly no lack of things to discuss, and we're pleased to have with us today Adam Acosta, who is a partner at White & Case Global Antitrust and Competition Practice, where he focuses on antitrust litigation, government investigations, and complex commercial disputes, who is going to be acting as our moderator. Before joining the firm, he completed a 2-year clerkship in Indianapolis at the U.S. District Court for the Southern District of Indiana. As a past president of the Hispanic Bar Association of the District of Columbia, Adam led one of the most active bar associations in the Washington, D.C. area. Just to let you know, we are recording this program. If you have any questions, please use the Q&A function at the bottom of the screen in the toolbar to ask your questions, and Adam will take care of those in due course. Adam, pleased to pass it on to you to get us started.
Great. Thank you, Glenn. This past February, the American Bar Association's House of Delegates approved a Uniform Antitrust Pre-Merger Notification Act drafted by the Uniform Law Commission, which was intended to be a model law for state legislators. Such laws would give states a role in the pre-merger notification process that has long been the province of federal regulators under the Hart-Scott-Rodino Act. The states of Washington and Colorado adopted the Uniform Act, and both laws went into effect earlier this year. And it's notable that both of those states filed standalone lawsuits in 2024 to block the merger between Kroger and Albertsons. Proposals to adopt the uniform law were introduced in other state legislators this year, and it's likely that similar proposals will reappear when states convene their legislative sessions in 2026. To discuss these developments and the growing trend of state law pre-merger notification laws and their implications, we're joined today by 2 merger control experts. Maureen Ohlhausen is a partner in the Washington, D.C. office of Wilson, Sonsini, Goodrich, and Rosati. In 2012, Maureen was confirmed by the Senate as a commissioner of the FTC and was appointed acting chairman in January 2017, a role she held until May 2018. Prior to that, she was director of the FTC Office of Policy Planning, where she led the agency's work on e-commerce and headed the FTC's Internet Access Task Force. A recognized thought leader, Maureen is a frequent author and speaker and is often quoted by leading print and broadcast media on antitrust, FTC, and privacy and data security matters. She serves as a member of WLF's Legal Policy Advisory Board. Also joining us today is Taylor Owings, a partner with Wilson Sonsini, practicing in the New York City office. Prior to joining the firm, Taylor served in the front office of the Antitrust Division of the U.S. Department of Justice from 2018 to 2021, first as counsel to the Assistant Attorney General and then as Chief of Staff. Earlier in her career, she clerked for the Honorable Douglas H. Ginsburg on the U.S. Court of Appeals for the D.C. Circuit and for the Honorable Richard J. Leon on the U.S. District Court for the District of Columbia. I'll now turn it over to Maureen and Taylor to get us started.
Great. Well, thanks so much, Adam and Glenn. Really appreciate the opportunity to speak with you all today about the birth of the baby HSR laws and what practitioners and just everyone kind of following along in the merger control space needs to know. I'm delighted to be joined by my partner, Taylor. She and I have counseled clients through this process and helped them maneuver to get their deals concluded in both dual federal and state review at the same time. So if we go to the next slide. So we'll go just to give you an overview. What are these mini HSR laws? Some of them are from the Uniform Pre-Merger Notification Act, but some are different, particularly with those in the healthcare space. The kind of key elements of them and state-by-state comparisons, and then practice tips, because this can really make a difference when you are negotiating a deal on the time, like kind of the time parameters, how long it's going to take, where you need to file, these state laws can loom really, really large in that. So if we go to the next slide, I can tell you a little bit about what are these mini HSR laws. And if we go to the next slide after that, so they are state level statutes, and they run coterminant, or they run alongside the federal HSR Act. I think we're all pretty familiar with the HSR Act. There are certain, documents you have to, if your deal trips, over a certain amount and needs to be filed with the state, with the federal government, the FTC and DOJ. Lots of documents need to be filed. There's certain set time limits. There's substantial, the government's on a certain clock. You substantially comply, then the government has 30 days unless there's a timing agreement. So I think everyone understands pretty well what those parameters are. Sometimes there are international filings that go along with that that need to also be resolved before you can close a transaction. But now we are getting much more involved in, not the federal level, not the international level, but the state level. And there's really been two types of mini HSR laws that have been adopted in the states. Many of them involve healthcare specific transactions, but there are also some that do not. They're not healthcare specific. And I mentioned the HSR Act, and we're used to, what the filing thresholds are for there. On the healthcare related requirements, it's usually not tied to HSR reportability. So you may have a transaction that your client is contemplating, and you think, okay, well, it's below the HSR threshold, no, contacts outside the US, we don't have to file anything. Well, just, be sure you may trip one of the state level requirements and end up having to file. So over the past 10 years, about a dozen states have implemented these mini HSR laws regarding healthcare transactions. And they're not every state is the same in how they identify what is a healthcare transaction. So they often use the definition of healthcare entities, and they define that further by statute. And that can really vary state to state, and we'll talk a little bit more about that. So it raises really some complexity where you may have to file in one state and not another for the same deal, even under one of these mini HSR rules. So, and it also, of course, depends on the context in the state. Then, as Adam already mentioned, there is the Uniform Pre-Merger Notification Act, which captures HSR reportable transactions, right? So that one has that similar, threshold triggering requirement as the HSR Act. And it's triggered where one of the parties has a principal place of business located in the state or has a certain amount of annual sales in the state, regardless of the business type. So it's not just for healthcare entities. It can be, Adam already mentioned, the grocery store mergers triggered these. So that also can be a factor that you need to consider when you're putting your deal together. So if we go to the next slide, so who are these potential healthcare entities, right? Some you think, well, that's very natural. You would think hospitals, of course, that's really common. Could be doctors, there are doctor groups, above a certain size, other healthcare providers, long-term or specialty care facilities could be captured, health insurers, pharmacy services. And so Taylor and I actually worked on a deal involving a virtual pharmacy that raised a lot of these issues, or drug delivery, and then telehealth or telemedicine services. So there can be really, I think, a broad collection of entities that could fall under one of these healthcare specific statutes. If we go to the next slide, we're going to talk about the Uniform Pre-Merger Notification Act, So again, this is HSR reportable transactions. So at least we know what those are pretty well. So the party has to have its principal place of business in the state, or it has an annual net sales in the state of at least 20% of HSR threshold, right? So around 25 million under current thresholds. So there's no waiting period. That's a big issue in sequencing your merger review when you can close. If the state imposes a waiting period. We'll get more into the details, but some of these healthcare specific ones impose waiting periods. So here, if you can close your deal under the HSR, you can close it, here, a state Uniform Pre-Notification Act obligation is not going to stop you from closing. Unless there's, some investigation, then they, are going to try to enjoin you. The new federal HSR form also includes a voluntary waiver for federal enforcers to share HSR filings and information with state AGs. So if that's how you wish to proceed, you have that option. It can be efficient. And then, as Adam mentioned, Washington and Colorado have adopted this UPNA model law language in 2025. So we're getting, some of our first experiences with how this will play out. So with that, let me turn it over to Taylor, and she'll give you more details on kind of how each state imposes its own flavor.
Wonderful. Thanks so much, Maureen, Adam, and Glenn. So I think the most practical way to learn about this subject is to really get into some of what might seem like the weeds, but it really, I think, helps illustrate what the practical realities are for parties figuring out where they need to file and what that filing is really going to mean for the timeline of the deal and for the burden associated with the merger review in a particular deal. So let's go into the state-by-state comparison. So this first slide is just to give you an overview of the places that you'll be needing to look at and assess your deal against their various state statutes. So if you have a transaction where there's a healthcare related element of it, you'll want to be looking at this list of statutes or list of states with healthcare specific statutes on the left side. And we'll get into some of the particulars about the way that these states define healthcare transactions. And even if your transaction is not a healthcare related transaction and you don't need to get into that sort of definitional question, you're going to want to look at California, Colorado, and Washington. As mentioned before, Colorado and Washington have passed the Uniform Premerger Notification Act, and as a result, you're going to need to put your HSR filing into those two states. But California has an additional non-healthcare specific statute. It's not the Uniform Premerger Notification Act. It's a statute for related to retail and drug retail transactions. So if you have a retail transaction on your hands, you're going to want to look and see if the California statute applies to you. Well,
and Taylor, maybe this is a good point for me to jump in and ask, what's driving these states to now get interested? What's driving sort of the purpose behind the Uniform Act? Why are we starting to see this now in other sectors outside of healthcare?
Yeah, that's a great question, Adam. So I think for a long time, the states were more informally involved in merger reviews and would coexist essentially with the DOJ and the FTC to essentially assert their sovereign interests as states to protect their citizens, the consumers that live in their jurisdiction. They would do this informally. They would read news reports of transactions happening. They might read news reports of the FTC or the DOJ issuing a second request in a merger review and realize that the interest in their state in this transaction was high, whether it be because it was the principal place of business for one of the merging parties, or because a lot of consumers in that state consumed the products that were being affected by the transaction. And they would be sort of in this dance of trying to get involved with the investigation on the federal level, but not having any specific rights to information unless they were to launch an investigation, issue their own civil investigative demands as they would under any state AG level investigation. So for many, the status quo prior to the Uniform Premerger Notification Act was sort of having to hear about transactions that might be of interest to states in this informal way, and then sort of chasing the process after the fact to try to get the information necessary to assert the state's sovereign interest. I think as you've seen states become more involved in the actual challenges to certain mergers, so I think back to the Sprint T-Mobile challenge that was led by New York State. Of course, not in the merger realm, but in the antitrust realm generally, we saw states be quite active and involved and press their own theories as to some of the big tech companies in the last 5 years or so. Of course, we've also seen as you mentioned, the state level challenges to the Kroger-Albertsons deal in Washington and Colorado. All of these instances of states pursuing slightly different theories than the federal government pursued, I think ripened this question of whether states really wanted to be chasing and kind of on the back foot of receiving initial information about what transactions they might want to take a look at. And as with anything involving 50 different states taking 50 different approaches, there are some real efficiencies and benefits, both for states and for parties, to have a uniform law that creates a single standard that companies know how to apply, know how to comply with, and can be relatively administratively simple, such as the Uniform Premerger Notification Act. All right, we'll go to the next slide. So we want to put on your radar that the list of states that you just saw in the previous slide is not the exhaustive list that you should be looking out for, because this is a very active area of legislation right now. The sort of furthest along states in adopting the Uniform Premerger Notification Act is listed here: California, Hawaii, Nevada, etc. So these are the states that very quickly could be added to your list of quickly filing the HSR filing after you put it into the federal government. You can do a double check that these state legislatures may have passed the Uniform Premerger Notification Act by the time you're getting your deal through merger clearance processes. It should also be on your radar that here in New York, we have a major revision to the antitrust laws that's currently pending. It's passed one chamber of the New York legislature, and then both chambers come back into session in January 2026. So there's a possibility that at the beginning of 2026, we're going to see some major changes to the New York antitrust regime. One of those changes is a comprehensive merger review regime. This would be, again, not the Uniform Premerger Notification Act, and not just limited to healthcare transactions. It would actually put New York more in the legislation as proposed would put New York more into a similar role as the federal government in terms of reviewing transactions that have a nexus with New York and would have their own pre-merger notification requirement. So that's something to watch out for in the future. We won't spend time on that today because legislation is messy and we don't know if this one's coming along. And then there are another handful of states that have legislation proposed that's specific to healthcare. And this includes states that already have a healthcare specific law that you will have seen on the previous slide, but some legislation is pending that would expand the scope of their pre-merger notification powers, including one trend that we're seeing, which is by expanding the definition of covered transactions to include investments by private equity into healthcare entities. So that's an example of something where there's been some action around the country in different state legislatures, including in California and Illinois. And Pennsylvania. So these are things to watch out for. Double check before you consider all your filings met. Have any of these states kind of close the deal on the legislation that's pending. All right, so now we're going to get into the questions that you really substantively want to ask of the transaction and compare against the requirements in each state's relevant law. So this is meant to serve as an overview of the topics that we're going to delve into with actual examples of how different state laws can differ on these topics. But you can see right away that this is a good laundry list of questions to run through to help prepare yourself for the real critical piece of deal negotiation, where you're going to be able to answer what your burden looks like in the different states and how long really the merger clearance process is going to take in each of the different states. So we will cover with some examples here the different states' approaches to the waiting period that has to be observed and the suspensory power, whether you need to hold off on closing your transaction until the state's review is done, who the covered entities are and what exceptions there are to having to file, whether there's a provision for distressed companies or other emergency expedited review provisions that you could perhaps take advantage of and speed your review, how onerous are the filing requirements going to be, how sensitive is your client to confidentiality? Is the deal going to be publicly announced, or is it a private deal that the parties don't want to announce until it closes? It's worth being aware that some of the states where you may have to file may expose the fact of the transaction to the public and ask for public comment. And then finally, what is the penalty if you get your interpretation wrong? Or if for some reason you end up closing around one of these state statutes. So we'll get into the different approaches in the next slides. So as the first example approach, basically the way we're going to go through these topics is by picking a couple of the state statutes that differ on these topics and give you a sense of how it will affect your process as when you're filing for merger review to deal with answering these questions. So the first topic is waiting period. How long are you expecting the state review to take? And how long in advance of the close of the transaction do you need to file with the relevant state? So a very typical approach is New York's, which is providing notice to New York 30 days before closing. One thing to keep in mind for this is whether you can file on a letter of intent rather than a final signed deal. Because of course, if you can file on a letter of intent, while the parties are still working out the particulars to the merger agreement, then you can kind of get out in front of this 30-day waiting period, and it may help speed your deal. The kind of converse approach and the longest waiting period in the bunch has been adopted by Oregon, which requires filing no less than 180 days before the close of the transaction. So this is, though 180 days is sort of by far the longest pole in the tent of these state laws, it's worth noting that the 180 days is the length of time that it could take for review in Oregon, not the length of time that will definitely take in Oregon. So you don't need to, it is not a certainty that your transaction will not be closing until 180 days after you file with Oregon, but it is a possibility. And the first checkpoint that you're going to get with Oregon, the first off-ramp that you're going to get with Oregon is after 30 days after they accept your filing. And we'll get more into what that actually means in Oregon. But so when you're thinking about deal timing, you want to plan for the fact that if you have to file in Oregon, you're going to need at least, I would say, 30 to 45 days from the time of putting your filing into Oregon to get a decision from them about whether they're in the concerned path or not concerned path, which would happen after that first 30 days. And I'll hand it over to Maureen for the next example.
Yeah. So to just give you sort of a sampling, an idea of who a covered entity may be, how complex that could be. We are just looking at the states that begin with C here. California appears twice, but here's the variety of definitions of who might be covered. So it's not in any way kind of consistent. There's some commonalities among the states, but there are a lot of different flavors. So, for example, in Connecticut, who does this law apply to? A covered entity is a hospital system, or other healthcare provider. And then that's further defined as a facility or institution to provide healthcare professional services, or an officer employee thereof. So, so you think of that as like a more traditional kind of facilities-based service provider, and there's no monetary threshold for that. Then turning to California, it has two statutes that could apply. So an acquisition involving a retail grocery firm or a retail drug firm, right? So kind of like, okay, who falls in those buckets? And these are defined by reference to NAICS codes. And if you're familiar with HSR filings, they're all divided up by NAICS codes as well. No monetary threshold there. Now, the California Office of Healthcare Affordability, their provision applies for acquisitions that meet monetary thresholds and then involve healthcare providers. And these are physician clinics, hospitals, clinical labs, and other healthcare facilities. So that is kind of facilities-based, but Taylor and I did a merger involving a sort of online specialty pharmacy that had some footprint in the state, and they were covered. They were covered by this. So it has you need to examine carefully the ins and outs of the statute. And then Colorado, which is again Uniform Antitrust Pre-Merger Notification Act. So it's not just limited to healthcare. And so it has either or conditions. So annual net sales in Colorado of 20% or more of the HSR threshold, which, the threshold changes with inflation. So annual net sales of $25.3 million in Colorado for 2025. So that could, potentially sweep in quite a number of businesses that would have to file then in Colorado. Or it has its principal place of business in Colorado. So if it's, smaller, has fewer than $25 million in annual sales in Colorado, if your principal place of business is there, you're going to be swept in. So again, these definitions of what exactly the business is involved and where its locations are and how much business it does in a particular state and what its footprint is in that state can be really, really important to figuring out whether you're going to have to file at the state level for your transaction. If we turn to the next slide, there are exceptions, hooray, right? There are some exceptions to these state statutes, but each state is a little different. So New York gives relief for a de minimis transaction. So it's kind of if it doesn't result in a healthcare entity increasing its total gross in-state revenues by less than $25 million. So you're going to really need to know some granular figures for revenues for entities to figure out whether you meet an exception or whether you are triggering a threshold to begin with. Indiana, we haven't really mentioned them too much yet. It exempts certain types of of insurance providers and then Medicaid and Medicare programs. And then Illinois, transactions involving an out-of-state healthcare entity provide notice only if the out-of-state entity generates, is that 10 million? I should put on my glasses, or more in annual revenues from patients residing in Illinois. Right, so it's trying, I think, to have sort of impact in the state kind of test, kind of in all of these. But so you may be exempt if you don't have that sufficient impact in the state, or not a specific type of entity. But you can see again, you need very granular information about the entity's operations and revenues in the state to sort through these things and see where you need to file. So I'm going to turn back to Taylor now to keep going through the laundry list.
Yes. So if you're not exempt, if you're falling within the definition, but you have an exigent circumstance, what can be done? Many of the state statutes have an emergency or expedited review clause. However, pretty uniformly, the burden to demonstrate what that emergency circumstance is on the parties, and it is quite high. So I think the right way to think about this as a practitioner is that unless you have easily available sort of good, solid financial records and evidence of imminent insolvency, then you're probably not going to find it worthwhile to engage in what ends up being sort of a separate track with the regulator to convince them and prove to them that your transaction qualifies for the emergency or expedited review, because that determination in and of itself and the evidence that they'll want, the back and forth on different financial records that could help you prove this, that in and of itself could end up taking the amount of time that it would have taken to get essentially clearance from the state authority. So it's a really sort of catch-22 situation. And I would say a practical tip would be, again, unless this is information that's easily available at your fingertips, and it's quite convincing of imminent insolvency, it may not be worth going down this road. And instead, you might want to be in a more advocacy forward position with the relevant regulator, letting them know of financial hardship or other deadlines coming up in the company's near-term future, letting them know about the dates of those deadlines and the practical reality of what's going to happen at those deadlines. I think when you establish a good working relationship with the relevant regulator, it's not falling on deaf ears. But again, as soon as you try to trigger these actual provisions, there's a sort of formal process that ends up, I think, a lot of the times distracting from the actual substantive review of the transaction, which if it's not hairy, if the substantive review of the transaction should be straightforward, maybe better spend it may be better to spend your time on that. So again, just as a big picture, imminent insolvency is usually the criteria, or if it's shy of imminent insolvency, but is going to result in the patient population in the state suffering some unavailability of services, that would also be a relevant triggering criteria for the emergency expedited review in healthcare specific statutes. Going to the next example. So filing requirements, of course, as you could anticipate from our sort of preamble on the healthcare specific transactions versus the Uniform Premerger Notification Act transactions, there are a wide variety of approaches to what you actually have to provide the state. Again, Oregon is the proverbial long pole in the tent, this time long pole on your side, because you will have to prepare quite a bit of information to put into Oregon. Whereas Colorado and Washington, you're just going to forward your copy of the HSR filing, essentially no additional work. But here's an example of the types of information that's really Oregon specific and requires you as the advising attorney to get ready and prepare separately from your HSR form. I'll hand it back over to Maureen.
Great. Yeah, so confidentiality is really another important issue here. As you are all aware, you can file, HSR. It's not necessarily made public, and the materials you provide are also not made public under the HSR. Well, the states are a little bit different if you trigger one of these statutes. So some are the same. Indiana, the party materials are kept confidential, right? So that's like the HSR. But you compare that to Massachusetts, where the party submission is generally kept confidential, except where the commission believes that such disclosure should be made in the public interest. So, we don't have a lot of experience with this to, quite know when they would decide that your materials need to be made public. But it is, different than the HSR requirements. And then whether the transaction itself will be made public apart from the materials that you submit. In New York, the summaries of the transactions are listed publicly on a web page. So your deal will be made public when that summary goes up. It's helpful, actually. When we've been counseling clients and figuring out whether a law applies or not for the states that do list these kind of summaries and descriptions, to go to them and say, did this type of party file, like if they're kind of, in a gray area. So it can be useful for counseling purposes to see other people's transactions that were filed, but it will make your filing public. Again, with Massachusetts, apart from the materials themselves, the fact that the transaction is posted on a list, and the competition evaluation is published on a webpage. So unlike, HSR, where they decide, not to give a second request, or they decide, have second request and close it, often those are non-public, or sometimes there's a little closing letter or statement, or if it's something of, kind of great public interest. But this is at the state level, there's more variation there. And if we go to the next slide, on penalties. So what does it all mean, right? If you miss filing, you think you're not swept in, but you are swept in, or you have to close and kind of close over a state review. What are you risking? Other than a challenge to the deal, what kind of penalties? In Indiana, there's no penalty. No provision for fees regarding the failure to comply. I mean, they may be unhappy, but there's not a fee that will be assessed. In Illinois, there's a civil penalty of not more than $500 per day, during which the healthcare facility or provider organization is in violation of the section. So if you found that you thought you didn't need to file it, but you needed to file, then you could be subject to this $500 a day penalty. In California, it specifies the AG can get injunctive relief and other equitable relief, and including attorney's fees and costs. And then on top of that, civil penalties up to $20,000 for each day of noncompliance. So you could see that could really add up, right? That could be something really substantial if you were, either been through not being aware of it, or just an interpretation where you came out in a different place than the state. If you don't file, depending on the state, it could be pretty substantial impact from that. All right, let me turn it back to Taylor.
And maybe I'll use this moment.
Or Adam, yes.
Yeah, let me ask a question, since, as you put it, there's really a complex laundry list of issues here to go through. And from a transaction planning perspective, when do parties typically need to start thinking about these issues and planning to address them, especially if you have transacting parties that are implicating multiple states or have a nationwide footprint?
Well, so when you're negotiating the merger agreement, or whatever it's called in a particular transaction, you really need to have a good sense then, because often you're assessing the antitrust risk at that point typically, and also putting in timing provisions, right? So often in an agreement, you have certain expectations of how long the deal will be held together, pending review, and things like that. So I think it really needs to happen then. And also for the parties to come to agreement on where these filings are going to need to take place, right? It's possible that one party thinks a state law is triggered and the other thinks it isn't triggered. So really, as early as possible. I wouldn't say that's always the case that people think about it that way, particularly because a lot of these statutes are new. So occasionally there's like a kind of a scramble near the end before signing to identify the states and then work back in some of these timetables. Particularly one like, was it Oregon? I think has 180 days. That's, a lot of deals, they're not really ready to be notified 180 days before closing. That's like 6 months, right? So some deals are on a much quicker time frame. So you could have some, challenges there, and you would want to have a provision that, the parties can't walk away from it that soon. So the earlier, the better, I think.
Yeah, and going into some other practice tips just like that one, Adam, I think is the way we want to sort of leave this group with things to keep in their mind, in the back of their mind, as they're going through their next transaction. So we're going to kind of frame up an example of, let's say you're representing a virtual pharmacy and they are selling themselves to an A side, to an acquirer. And let's say that an HSR filing is required. You've done that analysis. You are really going to want to take a hard look at whether a virtual pharmacy is triggering the healthcare related statutes in the various states that we've talked about, because if it is, and you don't see substantive concerns with the deal that could trigger a second request, then the states are very likely to be the long pole in the timing tent. I think, as discussed earlier, that 180 days is in Oregon is really the most challenging. But we're going to kind of walk you through how it's possible to get through that in more like 2 months rather than the full 180 days. So the first thing you would do in this example situation is to look at all of the definitional pieces of the statute to decide whether a virtual pharmacy is a healthcare entity under that state's statute. As Maureen mentioned, a lot of the statutes are facilities-based definitions. And so a virtual pharmacy that's mailing prescriptions into the state but doesn't have a physical facility in the state will not fall into the definition of a healthcare entity in that state. Where do you go for help interpreting what can be, vague, ambiguous statutory language? Some states have published guidance, and as Maureen mentioned, the previous examples of transactions that have been filed and the state's analysis of those transactions is available on some state websites, so that can be a helpful guidepost for whether your transaction is similar in kind. There's also a pattern and practice of states giving informal guidance. And what I mean by that is practitioners emailing or reaching out to the relevant office in each state and asking questions. And the more you have experience with these types of transactions and asking questions on behalf of previous clients, the more you're going to have a repository of understanding for how the state regulators themselves view the interpretation of the statute. Another touch point is looking, typical statutory interpretation stuff, looking at other statutes in the state to see how they define the same terms being used in the premerger notification requirement statute. And then there's always, especially if you're on the sell side, there's the possibility that you can plan in your transaction documents around a disagreement or an ambiguity in whether you need to file. So you can get the buy side's interpretation ahead of time, like Maureen said, and write into the deal terms what are the conditions for closing, including having filed and passed the waiting period for a specific list of states. Or you can write into the merger agreement that the buy side is going to take on the risk of closing around certain states. And if their interpretation controls and the acquisition closes and takes place, then the risk of having to pay penalties or otherwise litigate is going to fall on the buy side. So you can anticipate that and write that into your deal terms. Moving on back to Maureen.
Great. Yes. So as we mentioned, there's differences, between states, but even within states, there are some quirky parts to the statute. So for California, a retail drug firm, so that's covered. So there's retail grocery and retail drug firm are covered already. They, are not under the HCA in California. You have to sync up with the Board of Pharmacy for review of that. But California is also amenable to syncing up to overall deal timing and financial hardship. So there are these, ability to kind of like be flexible, responsive to the bigger deal considerations. Taylor mentioned the financial hardship is not automatically granted. It is, a pretty substantive inquiry that the state undertakes if you trigger that to ask for your deal to be reviewed more quickly. But we, we were able in a deal where we had the evidence that it was a real hardship. The state did eventually grant the expedited review. Oregon, so healthcare operations in Oregon, and the revenue thresholds there are not limited to in-state revenue, right? So that can really be sort of an unexpected factor, right? So maybe you have a lot of revenue somewhere else, but you have a tiny footprint in Oregon, you could still be swept under. We already mentioned the 180-day waiting period, which theoretically is very long, right? So you would want to account for that in your merger agreement, should it come to that. But it does occur in stages, and planned close date can be sooner. So some sequencing, triggers in your merger agreement. And it's really beneficial to stay in contact with Oregon reviewers about deal timing. And so, have a pre-filing conference with them because if your filing is deemed not complete, that can really slow you down. It's not unusual for them to take a while to resolve whether your filing is complete or not. There are redactions that need to happen, and that can be a significant source of delay if they don't agree with your redactions, if they think you're redacting too much or something like that. Here's another kind of funny factor in Oregon is the state has not devoted enough funds to the Oregon staff to do the work themselves. I don't mean any criticism of the Oregon staff working on these things, but the way they have sort of accounted for that is the state retains outside counsel to assist the review, and the parties get billed for the cost, right? So that's an unexpected, that's not like a normal kind of thing. So you may want to account for that in your merger agreement, like who's paying for that, because there is this, law firm bill from the law firm that the state has retained that is going to come due in one of these reviews.
That's a pretty interesting quirk, and I noticed with Colorado and Washington that they don't require filing fees with the Uniform Act that they just implemented. So how are states more generally going to fund, or are they going to really be able to truly and meaningfully scrutinize what's being reported?
So, like for example, in California, they have very experienced staff, people that I had dealt with before in antitrust reviews working on it. So I think they've just devoted kind of their state resources to it. But, realize that maybe in another state, they might be, even if they have sufficient staffing, those staff members might be stretched kind of thin. And to get the review done, if the state has a long review period in the statute, they may need to take the time to use it because of how they're kind of strapped for time. So that can be sort of a challenge that you need to keep in mind. But Oregon, it was so unusual that you start saying, I haven't heard of that before. It's kind of like if your HSR is getting reviewed and the FTC says, "Oh, we're kind of stretched thin, so we're going to hire some law firm to do this review, and then they're going to bill you for it." So, we're not there yet, right? The federal statute doesn't allow that. So if we just again, all this leads to your transaction documents, your negotiations. There are a lot of judgment calls involved, and you need to have a provision addressing if the A side and the B side come to different conclusions about the obligations. And so is a filing in Illinois required or not? We have this example. Who controls? Should the buyer's interpretation control? Since they're the buyer and they usually kind of get their way. But does it make more sense for the seller, right? Because it's their business that's being evaluated, and maybe they have more sort of on the ground knowledge about that. If the parties are fined or penalized for not filing, who's paying that bill, right? So would assume that maybe the person who is making the determination of whether you need to file or not would pay the bill if their assessment was incorrect, but you want to be sure that's worked out in advance. These are a lot of new kind of statutes, and some of their authority is informal or, given in kind of an email interpretation. How much can you rely on that? And then you're looking at, published guidance, that's great if the states have it, but to inform how you negotiate the antitrust risks and who pays what, and the timing obligations going into the transaction, rather than having an unpleasant surprise later on when something goes in an unexpected way. So with that, if we have any remaining questions, I'm happy to answer them.
Yeah, we have some time, and there's a Q&A function at the bottom of the screen if anyone in the audience wants to input a question. I'll ask a question in the meantime. Some of the state level healthcare specific reporting laws, they've been around for several years now. Has that led to states sort of becoming more active in scrutinizing those types of transactions, such that we might see more of that? It might sort of give us some insight into what we will see under the uniform laws that are being implemented.
I think that's a good point. And one of the things that we found when we were dealing with state reviews is they often were saying, we need this information from you so that we can answer questions, more broadly within the state from our, overseers. So I think that one of the things that's happening is there is some greater focus on antitrust issues that are being raised more broadly in the public and in legislatures and things like that. And so I think these states are gathering this information, even if the deal is, pro-competitive, competitively neutral, doesn't raise any issues, but for them to be able to kind of report back to say, we ask these questions, access is not going to be, suppressed or deteriorate under this transaction. Our citizens will still be well served by price or availability or quality, all the things, and then also some labor issues, right? So labor has become, and that's one. I think one of the reasons why healthcare, so many of these involve healthcare, is because they typically are very local. I mean, some of the online ones are not, but typically it's a very localized service, both for the access to it and the providers of that service. So I think that as those questions sort of maybe migrate from healthcare more broadly to, you see, grocery, that's also a very local kind of thing, that it may be something that if the Uniform Premerger Notification Act that's not industry specific proliferates, that's the kind of questions they would want to have answered. What does it mean for local availability, local conditions? In a national merger for a product that's available, online, it probably means, there's no particular local effect, right? Anybody can access it. But if it is a product or service that is just, again, more intensely local, then those kind of questions really come to the fore. Taylor, I don't know if you have.
Yeah, I was just going to add that we've seen relatively few examples of situations where the federal government's take on a certain merger diverges from what the state authority considers to be their local interest. But I think there is an atmospheric concern that the federal government may take different approaches under different administrations, or they may be resource limited. I mean, it's a fact, they are resource limited. And the question is, when is that going to come home to bite, right? When are they not going to be able to pursue blocking a transaction because it is, its impact on the nationwide group of consumers is relatively small, but the impact on the local group of consumers may still be very large for a particular state. And so I think states are preparing themselves to be able to go it alone when there's that real divergence between maybe the national sort of reasoning behind using resources on this transaction versus the local one. So we haven't seen it yet. Mostly the state and federal interests have lined up. So I'm thinking of United Amedisys, where there were local labor markets at issue, and a lot of local interest in the healthcare transaction. But the federal government went after that transaction and got a settlement agreement to divest a big chunk of the assets in that merger. So there was a line up there between the state authorities and the federal authorities, but states are getting prepared in case there is a mismatch for some reason.
Great. Well, I see we're at pretty much 2 o'clock, almost exactly. So I'll just conclude by thanking you, Maureen and Taylor, for taking the time to walk us through these laws today, and I'll turn it back over to Glenn.
Thank you very much, Adam. Appreciate your time preparing for this and for bringing us home right at 2 o'clock and moderating. And Taylor and Maureen, thank you very much for taking the time to prepare as well, and for an excellent presentation. If you happen to come in late to the program, this recording will be available on our YouTube page later this afternoon. And when you sign off, if you can take a moment to take a 5-question survey real quick, gives us a good feedback as to how our programs are going and how we're doing with them. Thank you again for joining us today. Everyone have a good rest of the day.
Thanks.
Thanks, everyone.